Hearing in the appeal, Skandinaviska and Conway and another.
Now, Ms. Chivers, before I begin, it might be helpful if I were to mention an authority that has it's occurred in court might be relevant, and which we didn't notice in the bundle. A case from Cayman last year called DD Growth Premium.
Yes. Is that the Privy Council?
Yes. Yes.
Yes, of last October.
That's yes. Judgment. Yes, right. Heard in October.
Yes, I was counsel in that appeal.
Like as you're well aware of it.
Thank you, my lord.
Yes, Mr. Chivers.
My lord, having said that, if the panel requires any particular submissions on the case, we'll clearly be happy to raise them. The appeal is conducted by myself with Mr. Ben Shaw and Mr. Kai McGreal for the appellant, SEB, and my lone friend Mr. Lord and Mr. Fulp appear for the respondent liquidators. The appeal raises 6 distinct issues. None of them are uninteresting, and none of them are unimportant, but necessarily I have to address them with considerable economy. I hope that my lords will excuse me, therefore, if I deal with authorities shortly, going so far as possible only to the key parts of that, and not dealing with facts, background, and so on. I'm afraid I'll ask the panel to fill in those details later. The second introductory note is to say that this is an appeal from Cayman. And so far as is relevant, the definition of insolvency in Cayman reflects the laws that stood in the United Kingdom before 1907. The definition of fraudulent preference reflects the law as it stood in the United Kingdom before 1986. And the panel is asked to put aside any preconceptions accordingly. While other jurisdictions have brought forward the time at which a company is deemed to be insolvent, have relaxed the rules for clawing back pre-liquidation payments, and have provided statutory schemes for the recovery of those payments, Cayman has done none of those things. Nor should the panel assume that that is anything other than a matter of choice. Given the circumstances of the Cayman fund industry, its importance to the jurisdiction, and the structures through which investments in Cayman funds are commonly made, it's not surprising, we say, if the legislature prioritizes certainty of receipt over the ability to claw back. This appeal, we say, is a case in point. The appellant, SEB, is a bank. It held shares in Weavering as custodian and nominee for 2 Swedish investment funds, Catella and HQ Solid. It acted solely on the instructions of the investment managers of those funds. It's also interesting to note that Weavering recorded the shares on its register as being held by SEB as nominee for Catella and HQ Solid, respectively. Cayman does not, as the UK Companies Act does, make provision that notice of beneficial interests should not be entered on the register of members. That is the position in the UK. It is not the position in Cayman. And in this case, the register of members did note the beneficial interest. Next, the redemption monies here were received from Weavering Company, those which the liquidator seeks to claw back. They were paid to SEB and credited to the bank accounts which SEB held for the funds, Catella and HQ Solid. Ultimately, those monies were paid out and the accounts closed. And as the expert evidence showed, and the judge found, SEB never had, and still has no ability to recoup those payments. So the consequence of the judgments below is that SEB must pay out of its own pocket monies which it only ever received as custodian and nominee, and in respect of which it has no right of recourse. And the panel will see immediately that if that is the position in law that prevails for funds operating through Cayman, the liquidity of those funds, the tradability of interest in those funds, the multiple layers by which funds of funds hold so that monies go up through layers of funds, could be significantly damaged. One can understand why a jurisdiction whose economy depends upon these structures might well choose not to expand the insolvency and clawback legislation in the way that a jurisdiction such as this one, where creditors normally arise out of ordinary trading activities or lending activities, rather than, as here, from people who never lent money to the company at all. These were shareholders. These were shareholders in the company whose status changes on redemption to make them creditors. Now that's a possibility, again, which in this jurisdiction simply couldn't have happened. In this jurisdiction, payment had to be on redemption. We didn't have this idea that you start off as a shareholder and you become a creditor. In Cayman, that is different. And therefore, the commercial circumstances underlying the legislation are different. And when Cayman chose to reenact the Companies Amendment Law in 2007, the last reenactment immediately prior to these events, it chose to stick with the pre-1907 English insolvency test and the pre-1986 English preference test. And that, as a matter of conscious choice, is fully explicable in circumstances of the commercial pressures on that jurisdiction. Finally, by way of introduction, the panel refused 2 applications on behalf of interested parties to intervene in this hearing. The outcome of this hearing will likely determine the outcome of some 20-odd cases currently stayed before the Cayman Grand Court. That's not simply because those cases turn on an identical point of law, but because the underlying facts in relation to those cases and this are identical. That's a matter of substance in this appeal, because you will see that so far as relevant, SEB, certainly in respect of what we will see are payments 2 and 3, was in exactly the same position as every other person who had given notice to redeem in December. Could I start, before going on to the law, with the articles of SEB? And you'll find those in the Record of Appeal at volume 3. At page 1379. My Lords, I believe the electronic record and the paper record have identical numbering, save, I think, in one, I hope, immaterial respect. But if there is any difficulty, please do let me know. At 1379, you'll see the Memorandum and Articles of Association, and the article, so far as is relevant, we just look very quickly at 1382. Halfway down, you'll see the definition of net asset value. It means the value of assets less the liabilities of the company calculated in accordance with these articles. Net asset value per participating share follows. 2 under that, incidentally, you'll see the offering memorandum. It means an offering memorandum relating to participating shares. We'll look at that shortly. Redemption day, over the page, means in relation to participating shares, such day or days may be specified by the directors in the offering memorandum. And redemption price, 3 down from that, means the price determined in accordance with these articles at which participating shares may be redeemed. You'll see the determination of net asset value at 1389. At paragraph 30, you'll see it's to be determined by the directors. It's to be determined by dividing the net asset value by the number of participating shares in issue. In calculating the net asset value, the directors shall apply such generally accepted accounting principles as they may determine. And then at 34, the assets of the company shall be valued in accordance with such policies as the directors may determine. Any valuations made pursuant to these articles shall be binding on all persons. And my learned friend will be relying heavily upon those last words. At paragraph 48, the provisions for redemption of shares come into play, and 48 we needn't read, but that tells you how you redeem by giving a redemption notice. And then over the page, the company shall redeem such participating shares at the redemption price, being the net asset value per participating share, and then there's a redemption fee. You'll see that the net asset, it's calculated on the redemption day. Paragraph 55, any amount payable to a member for the redemption of a participating share shall be paid in dollars. Company shall remit redemption proceeds, net the cost of remittance by cheque or wire transfer, within such period as the directors shall determine. I'll ask my lords just to note that. And then that's all the articles tell you about payment. They talk about redemption, but that's what they tell you about payment. Then the offering memorandum, which was referred to in the articles, you'll find at 1344. This is the offering memorandum by reference to which persons acquired shares in the company. $1344 is where it starts, and 1361, you'll see on the right-hand column under redemptions, halfway down, payment of redemptions. Redemption payments are generally made within 30 calendar days after the redemption day. No interest is paid from the redemption day to the payment date. Payments made by telegraphic transfer. And then at 1364, you'll see there's some provisions about the determination of net asset value. And you'll see that on the left-hand side, at A and B, there are specific provisions as to how, in accordance with international accounting standards, certain assets are valued. Cash, securities which are quoted, those are straightforward. Non-quoted, you'll see at C, the price is the opinion of the board. Prudently and in good faith by the board on the basis of foreseeable sales prices. And at D, liquid assets at nominal value. And E, all other securities and assets are valued at fair market value as determined in good faith, pursuant to procedure established by the board. And then 3 down from that, all valuations are binding on all persons, and in no event shall the board, the administrator, or the manager incur any individual liability or responsibility for any determination made or other action taken or omitted by them in the absence of manifest error or bad faith. My lords, that takes me to the first of the appeal points. It's what we've called the fraud point. And SEB says that the binding nature of the director's determination of the NAV, in this case, determined by them under Article 34, was vitiated by fraud. Now, there's no doubt that Magnus Petersen was the directing mind and will of the company. That's agreed in the statement of facts at issues. For your note, I won't go to it. It's at Bundle 5 at 1574 to 1575, paragraph 3. It's in the Court of Appeal judgment, paragraph 6, which is volume 1, tab 3, page 3. And there's also no doubt that he was a de facto director and had been delegated all the powers of the board. And that's in the judgment at paragraph 53, which is volume 1 at page 88. Those things are beyond argument. There's equally no doubt that the NAV was overstated as a direct consequence of Magnus Petersen's creation of sham swap instruments. Those instruments were created specifically to inflate the NAV so as to disguise trading losses and give the impression of modest but steady growth. And that's in the Court of Appeal judgment, paragraph 7, volume 1, page 3. Equally, there's no doubt that this conduct was dishonest, if that needs to be said. Magnus Petersen was sentenced to 13 years imprisonment in the Southwark Crown Court on the 23rd of January 2015. And yet the liquidators rely in this case on Article 34, the statement that any valuations made pursuant to these articles shall be binding on all persons. As to that, we say two things. Firstly, a fraudulent valuation is not a valuation made pursuant to the articles. Secondly, and in any event, Article 34 will not act so as to make a fraudulent valuation binding. And whether by operation of law or by necessary implication, it applies only to valuations made in good faith. We say these propositions should not be controversial. There's a short passage in HIH at volume 6, the authorities bundle, tab 12, at page 2049. The relevant passage is at 2065.
And is this an extra? I've gone straight to 2065.
Yes, it's from Lord Hoffman's judgment
In
HIH.
In HIH.
And it was a question of whether there was a relief of liability clause, and the question was whether that covered fraud. And Lord Hoffman said, 4 lines down, I agree with Lord Justice Ricks that fraud is quite different from negligence. Parties contract with one another in the expectation of honest dealing, particularly in an insurance contract. I think in the absence of words which expressly refer to dishonesty, it goes without saying that underlying the contractual arrangements of the parties, there will be a common assumption that the persons involved will behave honestly. As Lord Chancellor Lawburn said of the exempting clause in Pearson and Dublin Corporation, they contemplate honesty on both sides and protect only against honest mistakes. And then, just in response to Lord Grabiner's submission that allowing the insurers to rescind or claim damages for fraud would undermine the purpose of the truth of statement clause just as much as allowing to rescind for negligent misrepresentation. What Chase wanted was to insulate its rights under the policy from any misconduct. It wanted to be able to treat them as autonomous claims like documentary credits. No doubt, ideally, that is what Chase would have wanted. It does not follow that it is what the parties as reasonable people would have understood the clause to mean. Your Lordships will not refer to any case in which the language of the contract has been held to bar a remedy for inducing fraud, whether by the contracting party or his agent. Do not think that this contract does either. We've also referred in our skeleton to Jones and Sherwood, and I can take you to that very shortly. It's at volume 7 of the authorities bundle. It's tab 18, and the relevant passage is at 2254. And these are well-known statements that Lord Justice Dillon is here referring to. Now, at the top of the page, just under A, he's dealing with an expert certificate. Of course, we're dealing with a director's valuation, but the expert certificate can be no different in principle in this context from the determination by the directors. Necessary to see how the law stands on the question of challenging an expert certificate on the ground of mistake. We are not, of course, here concerned with any question of fraud or collusion on the part of the expert. And then the judgment of Lord Denning in Campbell and Edward, simply the law of contract. If two persons agree that the price of property should be fixed by a valuer on whom they agree, and he gives that valuation honestly and in good faith, they're bound by it. Even if he's made a mistake, they're still bound by it. The reason is because they've agreed to be bound by it. If there were fraud or collusion, of course, it would be very different. Fraud or collusion unravels everything. I'm sure, my lords, I don't say that as well as Lord Denning said it. But the statement was endorsed by Lord Justice McGaw, and we then have the judgment of Sir John Strange, Master of the Rolls, 1754. Whatever may be the real value is not to be considered, for the parties made Harris their judge on that point, and they thought proper to confide in his judgment and skill and must abide by it, unless they could have made it plainly appear that he had been guilty of some gross fraud or partiality. And then finally, on our authority, Sossamer International at volume 8, at tab 43, and the first passage is at bundle reference 2716.
Sorry, page?
2716 is the bundle reference. And paragraph 60, when a contract allocates only to one party a power to make decisions under the contract, which may have an effect on both parties, at least two questions arise. One is, what, if any, are the limitations on the decision-maker's freedom of decision? And what is to happen if the contractual power was not in fact exercised at the time when the relevant party was obliged to make a decision? My lords, we're not exploring the point, but of course that second question is a question we say actually has arisen here, because we say there was no proper determination of NAV. But the passage I'd like to take you to next is at 66, paragraph 66 on page 2718. It's plain from these authorities that a decision-maker's discretion will be limited as a matter of necessary implication by concepts of honesty, good faith, and genuineness, the need for the absence of arbitrariness, capriciousness, perversity, and irrationality. The concern is that the discretion should not be abused. And then reasonableness is discussed, but only in the Wensbury unreasonableness sense. Now, we say that that is very clear, it's very straightforward, and these NAVs, calculated as they were, upon the fraudulent swaps that Mr. Magnus Peterson, directing the will of the company, had inserted into the valuations, are simply not binding. But the liquidators say that Article 34, which I showed you, the provision that says that they're binding, governs this case, notwithstanding the fraud, because of the decision of this panel in Fairfield Sentry. So I must take you to Fairfield Sentry, which is at volume 6 of the authorities bundle, at tab 11, and it's page 2035, is the judgment.
I don't know if you're going to come back to this, Mr. Chivers, but I think might also be helpful to the board if you were to explain why the authorities that you've just cited to us apply on the facts of this case, where it might be said that the evaluation was made in good faith by the administrator.
Yes, I will address
You'll
that.
come back.
Yes, thank you. This case was also a case where the question of net asset value was being challenged by the liquidators. And you'll see that at paragraph 4, at page 2039, Lord Sumption summarises the proceedings which were brought at the instance of the liquidators, a number of financial institutions who are members of the fund but redeemed some or all of their shares before December 2008. Their purpose is to recover from the defendants the amounts paid out to them on redemption on the footing that they were paid out in the mistaken belief that the assets were as stated by BLMIS, when there were, in fact, no such assets. You may recall, this is the Bernie Madoff Ponzi scheme. The reference to the article starts at 2041, and you'll see a very close correlation between those articles and this. And you'll see at paragraph 13, Lord Sumption sets out Article 11. The net asset value shall be determined by the directors at the close of business, and so on. The calculation at B. And then C is a slightly different provision because it talks about a certificate, and that was of some relevance in that case. Any certificate as to the net asset value per share, or as to the subscription price or redemption price therefore given in good faith by or on behalf of the directors, shall be binding on all parties. Now, immediately, you see that this case could not have concerned a fraud in which the directors were involved, because the directors had to be given by or on behalf of the directors, but it had to be given in good faith. So immediately it tells us that Fairfield Sentry is no authority for the proposition that a certificate given other in good faith would have been binding, or that a valuation is binding where it is not given or made in good faith. Indeed, the question of the company or the director's good faith was simply not raised in Fairfield Sentry. The fraud was not the fraud of Fairfield Sentry. It was not the fraud of its agents. It was entirely external to the company. The valuation was wrong because of the fraud, but the fraud didn't taint the valuation or the process of valuation at all. It was simply an honest mistake. So all Fairfield Sentry decided was that on a proper construction of the articles, the binding nature of a director's valuation was not upset by an honest mistake. And the same would be true under these articles. We say this was not an honest mistake. The liquidators cannot distance Magnus Peterson's fraud from the valuation. As you've seen under the articles, it's the directors valuation. They have to value. It's not binding if it's not a director's valuation.
But they can delegate it.
They can delegate, but it's still their valuation. The liquidators can't distance Magnus Petersen because he was the controlling mind of the company. He was the de facto director. So if directors, Magnus Petersen, delegate the power of valuation to the administrators and then supply the administrators with a fraudulent valuation of an asset, or provide fraudulently to the liquidators a document which appears to have a certain value when the director knows it doesn't, and then they dishonestly publish that valuation, or dishonestly allow that valuation to be published, the valuation is tainted by fraud just as much as if the directors had conducted the valuation themselves. So the mechanical process of valuation may have been conducted by the administrators, but it remained the director's valuation under the articles. And if the director dishonestly interfered in that mechanical valuation by inserting a non-existent asset, so as deliberately to procure that the valuation was overstated, then it's not binding. The position is no different from an expert. If the expert produced a valuation as between two parties, and one party had dishonestly supplied the expert with information which tended to show that the valuation was increased or decreased of a particular asset, that party certainly couldn't rely upon that dishonest valuation. It would simply not be a valuation in accordance with the agreement. It's not an honest valuation carried out in good faith. The fact that you dupe someone else into doing some of the legwork on your behalf makes no difference. Now, the liquidators say the principle in Hampshire land, and I'll let my learned friend explain this to you, means that the knowledge of Magnus Petersen is not attributed to the company. But this question doesn't simply turn on knowledge. It turns on the question of whether the valuation has been tainted by fraud. One can test it this way. Suppose prior to the liquidation, the other directors had discovered the fraud after the redemption day, but before payment. So the redemption day comes along, the valuation is produced at an inflated NAV, but before any money is paid, an honest director pops up and says that was a fraudulent valuation, that there is fraud. This is an overstated value. Now the question is, would SEB have been able to sue the company for the NAV per share calculated on the basis of the tainted valuation? So clearly not. The company itself would have said the valuation is tainted by fraud and it's not binding. If SEB pleaded in reply, if SEB said in reply, well, you are bound because your directing mind and will, Magnus Petersen, knew about the fraud, then the company might have pleaded Hampshire land to say, no, for these purposes, his knowledge is not attributed to the company. You can't fix the company. You can't make a claim against the company on the basis that Magnus Petersen's fraud is attributed to it. It's the company that can raise in its defense. It can say, we can rely on the fact of the fraud, notwithstanding that it was committed by one of our directors. That's what Hampshire land's about, but I'll let my learned friend develop that if he wishes. But if SEB could not sue for the proceeds calculated on the fraudulent basis, then it's not a creditor in that amount. Now, it so happens in this case that the valuation was fraudulently overstated. But one can suppose a case where directors might fraudulently understate a valuation. If they wish to keep money in the company, perhaps because they were themselves non-redeeming shareholders, they might fraudulently understate the NAV and supply to the administrators material which showed that the company was less valuable. Perhaps they put some inflated obligations or liabilities to the administrators. Now, there can be no doubt that SEB would have been bound to accept, by way of redemption monies, a fraudulently understated NAV per share. SEB would have said that valuation isn't binding, it's tainted by fraud, and I require the true NAV per share to be paid out to me. There's a short point which I'll just mention. It's in our written case at paragraphs 39 to 42. And it was a rather strange episode at trial at first instance. I don't wish to take you to it now in any detail, I just refer you to it. This is that the liquidators acknowledged before the judge at first instance that they might yet seek to rectify the register of members on the basis that the NAV valuations were vitiated by fraud.
Well, Mr. Law doesn't like the way you put that in the case, so maybe that we'll have to look at the transcript and see what was said.
You may indeed have to do that, but as I say, I didn't wish to take up time on it, but it's a slight curiosity when one is considering the binding nature of the NAV. It's not simply a shareholder who might challenge the NAV, it's the liquidator, as in Fairfield Century. Either party might. It doesn't turn one way or the other. The question is, you look at the articles and you say, is this binding in the case of fraud? That's the first question. And the second question, which my Lord raised, is why is it that this particular valuation is tainted by fraud, where it was conducted apparently by an administrator? I hope I've indicated that. It's because the information was supplied to the administrator by Magnus Peterson specifically for the fraudulent purpose of procuring them to inflate the NAV.
How could Order 12, Rule 2 apply in this case if the requirement is that the company is or will become solvent?
Well, my Lord, because if the company gets in monies on this action, for example, and then pleads to rectify the register, it could say, well, we've now got enough money to pay all our lawful debts. Those debts don't include.
I see.
That was our concern at first instance. They were looking to have it both ways, that they put together a plan to redistribute the proceeds of recoveries, not amongst the redeeming shareholders, but amongst all shareholders, redeeming and non-redeeming, to try and do broad justice between them, taking into account the price at which shareholders had acquired their shares and so on, to see ultimately who was out of pocket and who wasn't. So that was something which the liquidators put in evidence, and was in evidence that they were contemplating doing. And it's on that basis, my Lord's quite right. How can this company be solvent? Well, if you falsify the NAV, it's exactly what we say you can do. We say then it is. The nature of these companies, of course, is that in general they don't become insolvent because the NAV is calculated to create a liability which exactly is matched by the asset available to meet the liability. So what we say here, what's the consequence of this? The consequence is that no NAV was determined in accordance with the articles. No sum became payable to any redeeming shareholder. Whether a redeeming shareholder could have sued the company for the true NAV per share, absent a lawful valuation, is something that this court need not be concerned with now. But there has, in any case, been no honest determination of NAV. And there is no evidence that the company was ever unable to pay out redeeming shareholders on a true NAV basis. Inability to pay debts must mean inability to pay debts which are lawfully due. there never were any debts lawfully due to the redeemers. They might have become due had they brought an action to determine NAV and so on, but there were never any debts lawfully due to the redeemers. So the company was never unable to pay them. There has never been any amount determined for which a redeemer could have gone to the company and demanded payment. My Lords, can I move on to the next point? So I'm sorry I have to move on quickly. There's a lot to discuss, I understand, on these issues. They're interesting issues, as I said. But I have to go on. The 30-day point and the future debts point, as they've been called, I'll take together, if I may. This issue is relevant only to the first payment. That's the payment of about $1 million, which was paid to SEB as nominee for Catella Fund. My Lords will recall from the facts that payments 2 and 3 were paid to SEB as nominee for HQ Solid, but this paid out the Catella Fund, the first payment. The starting point is the Cayman Companies Law, at section 145, and you'll find that in volume 8, at tab 50. I'm sorry, you won't find you will find the law there, and let me tell you it's the same as that which it was before the 2013 revision, but I'm afraid this shows the 2013 revision. But it's at volume 8, tab 50, at 2820. We will endeavour to, I think there is in the supplemental bundle, the 2007 revision. Yes. It's for your note, it's tab 18 of the supplemental bundle. My Lords may prefer that. It is the 2007 revision rather than the 2013 revision.
Do you have a page number in the supplementary bundle?
It's 195 of the supplemental bundle.
195?
Yes. Got the supplement. And you'll see there, this is the section under which this action is brought, 1451. Every conveyance or transfer of property, charge taken thereon, every payment obligation in judicial proceeding made, incurred, taken, or suffered by any company in favour of any creditor at a time when the company is unable to pay its debts within the meaning of Section 93, with a view to giving such creditor a preference over the other creditors, shall be invalid if made within 6 months immediately prior to the commencement of a liquidation. But you'll see that a trigger provision is that the company is unable to pay its debts within the meaning of Section 93. So that takes us to Section 93, which you'll find in the same bundle at tab 49. And you'll see a company shall be deemed...
The page of the supplementary bundle.
So, supplementary bundle, I think.
Which, as I understand it, is the correct provision in force at the time.
Yes, I'm afraid we don't yet have that. That was... We'll try and provide that for you, maybe.
Has it not changed?
It has not changed.
So what's the page number for...
Page number is 2818.
Thank you.
And it's Section 93. The company shall be deemed to be unable to pay its debt. So this is the trigger condition for a preference to be avoided. And then the first is a statutory demand. That doesn't apply here. None has been served. The second is execution of process, returned unsatisfied. That hasn't provided. So the only provision is it is proved to the satisfaction of the court that the company is unable to pay its debts. So the short question is this. Was SEB unable to pay its debts within the meaning of Section 93 of the insolvency of the Companies Law as at 19th of December 2008. And that turns on two things. The first is, does unable to pay its debts mean only those debts absolutely due, in other words, for which the creditor could go to the office and demand immediate payment? And the second issue is, if that's right, were the December redemption payments absolutely due as at 19th of December? Or did the company have a grace period of 30 days in which to pay? And I can deal with both points, I hope, very shortly. Section 93C is materially identical to Section 80, subsection 4 of the UK Companies Act 1862. That's in the Supplemental Authorities Bundle at tab 10 at page 178. And you will see the very close correspondence between the structure of that section and the Cayman section, with the difference that subsection 2 of the Cayman section necessarily doesn't need to include the subsection 3, which deals with the Scots position. But 4 is the same whenever it's proved to the satisfaction of the court that the company is unable to pay its debts. That was the subject of judicial determination in this jurisdiction in the case of Re-European Life Assurance, which is at volume 8, tab 31, at 2549. And again, to save time, it is a short judgment. It was given ex tempore. And the position just at the bottom of one bundled reference 2553, it's a reference to the company unable to pay its debts, or whenever the court is of opinion it's just and equitable. This case, as other cases that one comes to, contrasts the positions where technical insolvency has to be shown for the purpose of a statute, as against the position where the court has the discretion to wind up on a just and equitable ground. So the fact that the company isn't deemed to be insolvent doesn't mean that the company necessarily can't be wound up, although it may affect who's entitled to petition. And then the Vice-Chancellor deals with the payment of debts at the top of the page, over 2554, with regard to the payment of debts, certain things given as indicia of inability to pay debts are following the general clause empowering the court to make an order whenever it's proved to the satisfaction of the court the company is unable to pay its debts. Now, it's not suggested the company has been unable to pay its debts in the sense that it has failed to pay every demand which has been made upon it. It's not suggested that it has not found the money to meet everything that has become payable in due course. The words due course are used there, and we'll see them elsewhere. But here, of course, the learned judge is looking backwards. He's saying, has the company failed to pay a debt that fell due in due course? No. And then he says, it's not suggested, therefore, at all events, there's no evidence before me that in the sense of debts actually due, within the meaning of the first clause of the 80th section, any debt due and payable has not been paid. It's contended the company is unable to pay its debts in the sense that it's been obliged to pay the amount of assets not properly applicable to them, and hand to mouth and so on. Now, one needn't be concerned with that, but just going down to the bottom, 6 lines up from the bottom, I apprehend that Mr. Glass is right in his construction that inability to pay debts must refer to debts absolutely due. That is to say, debts for which a creditor may go at once to the company's office and demand payment. The case has therefore been put really and substantially not upon the ground of actual inability to pay a debt actually due, but upon another ground, and that's the fifth subsection, that's the just and equitable winding up. And then there's a discussion with regard to that and the general solvency of the company. But the case, as we will see, has been subject to a certain amount of comment. But what one can certainly say about the case is that it has stood for 150 years and has been taken to represent the law on the meaning of those words. Now, the UK Companies Act was amended in 1907 specifically to add an element of futurity to this test. So the 1907 Act provided that the question of inability to pay debts would be having regard to contingent and prospective liabilities. It was forward-looking. So from 1907, the UK legislation has always been forward-looking. The Australian legislation, and there's some reference in my Lord Briggs's decision in Cayman Finance to an analysis of the Australian decision. The Australian legislation has always included the provision of payment of debts as they fall due. So those words, as they fall due, have been included in the Australian legislation. So what we have in Cayman is a relic from the 1862 Act, which Cayman has stubbornly, some might say, reenacted and reenacted and reenacted, but it has reenacted it in the face of European life assurance and the court's determination of the meaning of those words. Now, the UK Insolvency Act further amended the law in 1985 and 86 to add a balance sheet test and to add futurity to the cash flow test by adding the words as they fall due, as in Australia, to unable to pay its debts. And this was all analysed by my Lord Briggs in Cayman Finance, confirmed by the Supreme Court in Eurosale, and we should go to that. That's at bundle 6. Authorities bundle 6. My bundle 6 there, by any chance? No, it's all right, I've got it. Bundle 6 at 1822, you can pick it up there. This was dealing with the construction of a contractual term, but it was not suggested that the meaning of the words were any different or that the analysis was any different. So one starts at 1822, where Lord Walker sets out the statutory history of the UK insolvency legislation. And one can pick it up at H, where he says it's necessary to look quite closely at the legislative history. The starting point, section 79 and 80 of the Companies Act 1862, and stated whenever it's proved to the satisfaction of the courts, the company is unable to pay its debts. And then he says, so a contingent or prospective creditor could not present a petition, but if another creditor presented a petition and secured a winding up order, contingent and prospective liabilities were admitted to proof. European Life Assurance, the Vice-Chancellor dismissed a petition for the winding up of the company which had issued large numbers of life policies and annuity contracts and appeared to be in financial difficulties. Extemporary judgment decided with very little reasoning, inability to pay debts must refer to debts absolutely due. Proceeded to consider and dismiss the alternative just and equitable ground. Now, He then went on to consider balance sheet, as Lord Walker says, and at the bottom of 28, he was applying a balance sheet test, but only to existing liabilities. So there's some criticism there of the Vice-Chancellor's looking at the position on the just and equitable winding up by applying a balance sheet test which is solely focused on what's there on the balance sheet as regards existing liabilities. But the law was then changed in respect of life assurance companies, and then the same change was made in respect of the Companies Act 1907. You'll see at the bottom of H, the amendment was introduced on the recommendation of the Lawburn Committee. And then there are some authorities, I think some English authorities there. And this is focusing essentially on questions of the balance sheet. But if you look at paragraph 32, having dealt with Byblos Bank, one should say, Byblos Bank Lord Justice Nichols, where he referred to the judgment of in European life assurance, including the passage commented, in my view, the exercise described as the exercise required to be done under 223. In my view, these authorities go quite a long way to establishing that neither the notion of paying debts as they fall due, nor the notion of balance sheet insolvency was unfamiliar before the enactment of the Insolvency Act 1985. But of course, the notion of paying debts as they fall due was unfamiliar prior to 1907 because it was only the element of futurity that had been put into the cash flow test, as it was then in 1907, by having regard to contingent and prospective liabilities. There is then a reference to my Lord Briggs' judgment over the page at 1826 of the bundle in Cheney Finance, referred to similar language as they become due used in Australian companies legislation. As they become due, a phrase which looks to the future. And we say, as they become due is a phrase which looks to the future. Inability to pay debts is not a phrase which looks to the future. And one sees the analysis, Lord Walker's analysis and my Lord Briggs' analysis, is the same at 34. It's therefore necessary to consider how far Section 1231E was concerned, not only with debts that were immediately payable, but also with those that would be payable in the future. As Justice Briggs decided rightly, in my view, that this is what Section 1231E requires. In my judgment, the effect of the alterations to the insolvency test made in 1985, now found in 123, was to replace in the commercial solvency test, now in 1231E, one futurity requirement, namely to include contingent and prospective liabilities, with another more flexible and fact-sensitive requirement encapsulated in the new phrase, as they fall due. My Lords, the Cayman Court of Appeal has confirmed that European life assurance remains the law in Cayman, and that's in Strategic Turnaround at Volume 6, pages 2000 to 2001. And you'll see the reference to the authorities, European life assurance, and then at 42, at the bottom of 2001, for these reasons, therefore, it seems to me the respondent did not have locus standi to petition on the unable to pay its debts grounds as a creditor with a future debt. The respondent's debt was one that was not presently due and payable. So Justice of Appeal Voss was in no doubt that European life assurance represented the law in Cayman and restated it. It's a decision of 2008, and of course one can't really, I don't know, one can say that the 2013 restatement of the company's law in Cayman would have been done with full cognizance of this provision, just as of this decision, just as the 2007 law would have been with full cognizance of the law in European, the decision in European life assurance. There is a clear principle. We've included Barras and Aberdeen sea trawling in the bundle at volume 6, tab 2, at 1763, but you can pick up the judgment at 1772. And it's to do with the meaning of the word wreck. And there had been previous authority in relation to the Olympic collision, which had given expression to that, and then there had been a new enactment using the same words. And what was said by Viscount Buckmaster was the respondents based the main part of their case upon the ground the Olympic was wrongly decided, that the limited and relative meaning there attributed to the word wreck is not the true interpretation of the phrase. Well, we'll see what my learned friends are now trying to do with the wording used in Cayman. I do not think that the consideration of that question is open to this House. It's long been a well-established principle to be applied in the consideration of Acts of Parliament that where a word of doubtful meaning has received a clear judicial interpretation, the subsequent statute which incorporates the same word or same phrase in a similar context must be construed so that the word or phrase is interpreted according to the meaning that has previously been assigned to it. And that is expanded by reference to ex parte Campbell. There's a reference to the need to give certainty at page 412. And my lords, that would all be all of this case one needs to go to, save for at 414, 1775, any of my lordships with interest of a nautical flavour will be interested in the account of the Olympics collision. But my lord, I won't take you to that. That's my lordship's note. The only thing to note is that the Olympic, sister ship of the Titanic, which collided with HMS Hawke in 1911, gave rise to an interesting legacy for those two ships. One of them was sunk by a U-boat and one of them sunk a U-boat. Not perhaps those that you might think. It was HMS Hawke that was sunk by a U-boat in 1914 and the Olympic sunk a U-boat in 1918. One wouldn't have thought, seeing those two ships together, that that would have been the outcome. My lords, that's enough of historical interest. Can I go to the next question, which is when the December redemption monies became absolutely due and payable? So when could SEB have gone to the company and demanded payment? That turns on the articles, and I've shown you those in the Record of Appeal, 1379. My learned friend says, under strategic turnaround, which is volume 6, tab 9, at 1981, the decision in the Privy Council, which is at tab 10, is binding and decides this issue against me. But one has to see what the issue was in strategic turnaround. Very quickly, the issue was whether an existing creditor could petition on the grounds that the company was, at the date of the presentation of the petition, unable to pay its debts within the meaning of the statute. And my lords have seen what Justice of Appeal Voss said about that. Now, the ground on which he said that the debt wasn't currently due was that there had been a suspension by the directors. They had suspended payment of the debts as they were entitled to do, as the Court of Appeal said, under the articles. Now, it's just worth looking at the head note of this just to get the dates right. The head note at 1981. at the bottom of the page, or rather in May 2007, the respondent had subscribed for shares. 31st of October 2007, a redemption notice was given. Redemption date was set at March 31st, 2008. Payment of 90% of the value, with the balance to follow, was agreed by the company to be made by the end of April. So payment date due at the end of April. The redemption was then confirmed by the company's administrator, payment arranged within 30 days of confirmation. On April the 17th, however, the directors suspended all redemptions due to the volatility of the sector. And on May the 1st, the respondent contacted the company, reminding it that the administrator had confirmed the redemption. The respondent then filed the present petition to wind up the company. I don't have the petition date to hand, but what you'll see immediately is that the petition was presented after the 30-day period. It was not presented on, or even within a month of, the redemption date, which is when Culross became a creditor. It was presented afterwards. So the petition could only be defeated if the 17th of April suspension was effective as a matter of contract. And the Privy Council, in tab 10, said that there was no power to suspend. It was all a matter of contract, and you had to look at the articles. Now, what you'll see from these provisions, the articles are set out by Lord Mance in this judgment, the articles in the Culross case, strategic turnaround. And if you go to page 215 of the bundle, there are the definitions in the articles.
I'm sorry, which page are we on?
I'm sorry, in the bundle it's at 2015.
2015.
And then if you look at 2016, you'll see provisions relating to redemption of shares. And you'll see the price over the page, not unfamiliar to that which you've seen in relation to the current articles. And you'll see at paragraph 38 of the articles, at 2018, any amount payable to a member shall be in dollars. The company shall remit redemption proceeds, check or wire transfer. In the absence of directions, remit redemption proceeds by check. You'll see that the wording, within such periods as the directors shall determine, is the same wording that we have in the Articles of Association in this case. So the articles were materially identical for the point that we're looking at. Lord Mance then referred to the offering memorandum, and you'll see that at the relevant part at 2023 of the bundle, payments upon redemption. Payment of the redemption price will be made as soon as practicable, but except in cases otherwise described herein, a shareholder who is making a redemption will receive at least 90% of the redemption price no later than 30 days following the date of redemption. Now, one can contrast that. It's not very different, save this relates to 90% only, from Weavering's articles, which say, so the Weavering offering memorandum, which says that payment will usually be made within 30 days of the redemption date. Then we look at what Lord Mance made of this. He was considering, of course, only this question at paragraph 15 at 2024, whether the company had power to suspend the payment of redemption proceeds after the redemption date but before payment of those proceeds. Paragraph 18, he deals with the articles dealing with redemption. He refers at paragraph 19 to the clarity and formality of the provisions regarding the giving of redemption notice and the ascertainment of the redemption date and price, with the open provision regarding payment in Article 38. However, Article 38 cannot permit the respondent's directors to delay payment beyond a reasonable time. And this is highlighted by Article 37, which is the only provision in terms expressly authorising the withholding of payment of a redemption payment. And then he talks about the liability until the price is paid in Article 53. At 20, the focus of these provisions is on the redemption date by reference to which the redemption price payable is crystallised and from which the price is deemed to be a liability of the respondent. The remittance of the redemption proceeds is treated as a matter of supplementary procedure, though it may be refused on money laundering grounds and so on. And he talks about the continuing process. Now, the argument that was being run before the panel there was that the shares weren't redeemed until the conclusion of that process. So you had to have redemption notice, redemption day, payment, and only then were the shares redeemed. And the panel rejected that. We're not concerned with that. In this case, we accept that from the redemption day, SEB became a creditor. It begs the question of when the payment was due. But that is answered by Lord Mance at paragraph 33, or to a degree answered by Lord Mance, at page 2030. He says, two of the provisions of the CEM call for further mention. The first, under the heading of payments upon redemption, contains assurances regarding the timing of payments of any redemption proceeds, which have no parallel in the articles. These may be regarded as the director's determination, for the time being, of the periods within which such proceeds are to be remitted under Article 38. Now, my learned friends also rely on Lord Mance in Primio, and I'll just give you the reference if I may. I won't take you to the case. My learned friend can if he relies on it. But there's a reference at 723-2405 to Lord Mance referring to a short period of credit. It's the wording that he uses. And we just say, in this case, that period was no less than 30 days. Now, we've set out in our written case, and again, I haven't got time to take you to it, paragraphs 79 to 84, the authorities on the implication of a reasonable time where an agreement does not itself set out the time for payment. Those authorities are not, no issue has been taken with those authorities. My learned friend relies upon strategic turnaround in Primio. But those cases, as we've seen, are fully supportive of SEB's case and don't damage them in the slightest. So the consequence is that as at the 19th of December, we go back now to the 19th of December 2019, no December redeemer could have come to the company and demanded immediate payment. The directors had a discretion, a contractual discretion to withhold payment for a reasonable period. And 30 days was not unreasonable, being the period notified to investors when they acquired their shares. Alternatively, per Lord Mance in Strategic Turnaround, the directors had actually decided on a 30-day period by issuing the offering memorandum, and that was the contractual period for payment. But either way, no December redeemer on the 19th of December could have petitioned to wind up the company relying on Section 93C. The December redeemers were undoubtedly creditors, but they were not creditors whose debt was currently due. Their debt was payable in the future. The company was not unable to pay its debts, and Section 145 could be of no application to any payment made on the 19th of December. Well, as I must move on to the preference claims themselves, and for the purpose of this appeal, SEB does not contend that the first payment on the 19th of December was made other than with a view to preferring SEB as nominee for Catella within the meaning of the section, subject to the solvency point that I have raised. So this issue concerns only the second and third payments for reasons which I'll come on to, it has a consequence of the first payment, but the analysis concerns only the second and third payments. On the 2nd of January and the 11th of February, respectively, paid to SEB as nominee for HQ Solid. My Lords, at Bundle 5, 1596, you will have a payment schedule. I can't read it, and both sides have produced versions of that schedule which are legible. Could we hand up, my learned friends is better than mine, could we please hand up versions of this schedule? This is exactly the document that is at page 1596 of the bundle. What this is a schedule of December, January, and February redeemers. And if you work up from the bottom on the first page, you'll see that there are 6 payments which, in the yellow box, say full payment made on the 19th of December. And those were the payments to Swedish investors where it was thought that Magnus Peterson might persuade them to reinvest in a new fund of his. That seems to be the suggestion as to his motivation for requiring them to be paid earlier. And SEB is listed there as nominee for Catella. Leaving that aside, you'll see that there are a series of payments in the yellow box by reference to these various December redeemers. Partial payment 1 with a payment date of the 2nd of January, and partial payment 2 with payment dates that are mostly the 16th of January, a number on the 27th of January, but you'll see SEB, 6th from the top, did not receive its second payment until the 11th of February. It was amongst the last 2 to be paid. You'll also see that 2 HSBC Private and Summers Dublin, for the account of Signet, didn't receive their second payment at all. Now, these payments, if you add them up and divide them out, the 2nd of January payments represent 25% of the outstanding redemption monies in respect of each of the December redeemers. The balancing payment represents, in each case, I believe, 75%. So those that were paid in full were paid in 2 tranches, 25, 75. Those who weren't paid in full were paid the 25, leaving aside the 6 Swedish investors who were paid out on the 19th of December. Now,
I think I read somewhere that by March all the December redeemers had been paid, but that's not right.
That's not right, no. No, the two of them remain unpaid, I believe. So, three of them.
You mean the top one, the third one?
Oh, sorry, yeah, it's the second as well. The 10 million was not the complete. If you look at the funds owed, it was the funds due. There was another 29 million to come. The 10,000 was the 10 million didn't represent 75%.
Right.
So that was my mistake. I'm obliged to my learned friend. It's the top 3 that remained unpaid in part.
Which were the 3 largest?
Yes.
Yes, redeemers.
Now, what you'll see from this schedule, firstly, the payments to SEB for HQ Solid weren't made in advance of the payments made generally to other December redeemers. On the contrary, SEB was one of the last to be paid. Not all of the December redeemers were paid under that policy. There was no finding as to why those particular redeemers weren't paid, although it does appear that it was because they were the largest ones and there probably wasn't enough money to make a complete second payment in respect of them. The probability is that the company chose where it could to pay off redeemers in full rather than to make part payments. So one supposes it would have fewer angry creditors to deal with and eliminated the vast majority of them in respect of the December redeemers. Now, at first sight, it's an unusual preference claim because to succeed, the liquidator has to show that the company paid SEB with a view to preferring it over other creditors. And there's no dispute as between the parties that that means the company must have had the dominant purpose of preferring SEB. At first instance, the judge found that the company, in fact, Magnus Petersen, because for these purposes they're the same thing, did have the dominant purpose of preferring SEB over the other creditors because that purpose existed in respect of the first payment, the 19th of December payment, and hence continued to exist in respect of the second and third payments. They were infected by the first payment. That reasoning was rightly overturned by the Court of Appeal, and it's not pursued. Put shortly, evidence of an intention to prefer SEB as nominee for Catella can be no evidence of an intention to prefer SEB as a nominee for HQ Solid. There's no cross-appeal against that. But absent any continuing dominant intention to prefer SEB, the judge did not find any other evidence of intention. On the contrary, as he said at paragraph 188, if we look at his judgment at volume 1 of the record, at page 143 of the record,
What was the page again, please?
Sorry, it's page 142, in fact. It's record, volume 3, page 142, paragraph 188.
I thought he does add a second point in the last sentence of 187, Mr. Chivers.
Yes, and I think the Court of Appeal pick up on that.
I think they do.
They do, and I will deal with the Court of Appeal's analysis of
Yes,
that,
fine.
if I may. But if one, it's the intention appears to have been reinforced, but he doesn't rely on those particular decisions as evidence of intention in their own regard. And that's important when we come to 188, because he says, having regard to my conclusion as to the specific intention to prefer SEB, it's not necessary for me to decide whether, absent such specific intention, the required intention of preference can be inferred objectively from the facts of such payments being made when the company was commercially insolvent. This may well have to be resolved if claims are pursued against other redeemers. In such cases, it can be anticipated there will have to be weighed against such inference any other particular reasons in those individual cases why payments were made, such as pressure being brought to bear. May also be necessary to consider whether perhaps the evidence is equivocal. Balanced against any inference of preference, it may have to be considered whether payments were simply made at random, or perhaps to play for time to keep the company going, in the hope of Magnus Petersen to avoid detection of his fraud as long as possible. So the evidence before the judge was not sufficient to determine that there was a preference in respect of any other person on this list.
Well, why wasn't there a preference to pay everybody apart from the top three redeemers?
Well, my lord, the question is, we'll come to the legal test as to what preference and intention to prefer and with a view to prefer means in this context. But there was no evidence. There was no evidence that Magnus Petersen wished to pay one creditor ahead of another creditor, that he had that that was his predominant intention. The question is, what evidence was there before the court, other than in relation to the 19th of December payments, which would justify a conclusion of preference? The judge didn't find any. Indeed, he said there would have to be further inquiry, because there are other issues that come into play once you take SEB out of the equation. Now, if SEB is in materially the same position as all of those other payees, then there was nothing before the learned judge at all to justify the finding that SEB had in fact been preferred, because exactly the same issues which might arise in relation to other payees, such as Magnus Peterson trying to avoid being found out in respect to his fraud or delay the evil moment, would apply to SEB just as they, in relation to HQ Solid, just as they applied to Bear Stearns Alternative Access International Limited. There's also we'll understand why, in relation to the Court of Appeal judgment, the 20-odd redeemers, two of whom sought to intervene, were particularly disquieted by it, because it seems to negative what the learned judge said about other redeemers being in a different position of SEB. Now, the Court of Appeal, if we take the Court of Appeal dealing with this question at paragraph 56 of Bundle 1 of the record.
Page.
It is at page 30 of the bundle. Now, paragraph 56, if I could ask my lords quickly to read paragraph 56, which is the heart of the point. Now, my lords, one can pick it up at the bottom of the middle of the paragraph on the left-hand page. The judge regarded his findings as merely reinforcing his view that the payments to SEB were made pursuant to giving a preference to investors in the Swedish fund, but then there's a reference to the letter of the 31st of December, at least having a significance of its own. It might be worth just looking at that letter now, very quickly. It's a very short letter. It's at the same volume, it's at volume 3, sorry, at 1416.
I'm so sorry, can you give me the page number?
Yes, it's 1416.
1416, thank you. Yeah.
And it's dated the 31st of December, although it appears it was sent out on the 7th of January.
Yeah.
Due to which was after the 25% had been received by all of the December redeemers. Due to the illiquidity of the markets, the fund has received redemption requests over 30% of NAV. Directors have exercised their discretion to postpone a pro-rata proportion of existing redemptions until the market conditions improve. Reducing positions in December's market conditions to create cash has proved difficult. Therefore, after consulting Weavering Capital, the fund's investment manager, that incidentally is Magnus Peterson, so Mr. Peterson is consulting himself, in order to effect an orderly liquidation of the fund's assets to meet the request of redemptions, Directors have decided to pay at the end of this month 25% of all redemptions requested at the end of November on a pro rata basis. Remaining redemption amounts will be paid in one or more instalments as market conditions improve. Directors envisage will take place by the end of January. Now, it's difficult to see, with respect to learned justice of appeal, how that has a significance of its own in terms of preference. There's no statement there that the company, that Mr. Peterson wishes to prefer the December redeemers over any other redeemers. The identity of those redeemers is perfectly irrelevant, one supposes, to a letter of this sort. If the January redeemers happen to be the December redeemers, rather than the way round it was, one supposes exactly the same letter would have gone out. So there was nothing about the identity of the December redeemers that you can glean from this letter which shows an intention to prefer anyone. On the contrary, it's actually deferring payments rather than advancing payments.
But Mr. Shivers, that might be all right if they had done what they said they were going to do on the 31st of December, but in the third paragraph they say that they will have decided to pay them on a pro rata basis. But they didn't do that. They discriminated, to borrow a word from another field of law, they discriminated against the three largest redeemers.
No, not in respect of that payment, my lord.
This is what they...
The 25% was paid pro rata to all of them.
Well, with respect, is that on the 2nd of...
Yes.
Oh, on the 2nd of January,
Yes.
it was the later payment.
That's the third paragraph, my lord.
It's the 75% that wasn't paid to the...
But they did what they said they'd do.
At that time, thank you.
Now, the learned judge also assumed that, as at the 2nd of January, the January redeemers had fallen due for payment as well. For reasons I've given, they didn't fall due until the end of January. But,
well, if you're wrong about that, your second and third payments were preferred over the January redeemers.
As a matter of
if
fact.
If you're right about that, let's concentrate, as we already have, on the three large December redeemers. Your clients were preferred over them.
As a matter of fact, yes, my lord. But one has to...
And then why can't there be an inference with a view to?
Well, my lord, we'll come to the authorities, if I may.
Okay.
Of course, we have to look at the facts, but we have to look at them in the light of the authorities. I hope I'll answer my lord's question as to why there can't be an inference. The learned justice of appeal then, at the bottom page, the proper course would have been to suspend redemptions or liquidate the company. Well, that may have been proper, but it didn't happen, and we're not concerned with what didn't happen. He nevertheless caused the company to adopt a policy designed to allow the December redeemers to be paid before other redeemers. Now, the use of the word designed comes from nowhere. It's with the effect. It had that effect. It certainly had that effect. But to say that it was designed to allow that, allow them to be paid, is putting a finding on it which simply isn't based on the evidence. Certainly it had that effect, but as we'll come to in the cases, when you're looking at motivation and intention, looking at effect isn't sufficient. Again, the second SEB redemption payment and the third payment were made pursuant to this policy and had the intended effect of preferring SEB as one of the class over the body of January redeemers. Now, again, it had that effect, but to say that it had the intended effect is to jump to the conclusion a little too quickly. And going down the paragraph, the policy may have been applied consistently in relation to December redeemers. It did give SEB an advantage over January redeemers, in the case of third payment, the February, all of whom were to the knowledge of Magnus Peterson unlikely to be paid. That, in my opinion, is sufficient to justify the judge's conclusion of a specific intention to prefer. So the mere fact of preference has been used by the Court of Appeal to justify the specific intention to prefer. Now, at 57, the learned justice of appeal then says, I do not find it necessary to address the more general question raised, namely whether the fact of payment in knowledge of insolvency is sufficient without more to found an inference of intention to prefer. But that's exactly what the learned Lord Justice did at 56. He relied upon the letter of the 31st of December, but that shows no intention beyond the mere fact of payment. This is what we're going to do. It doesn't show that that's being done with a view to preferring, simply showing that that had the effect of preferring. And then the minutes that were relied on, I think there's, with respect again to the learned Lord Justice, there's nothing in this. Just for your note, it's at bundle 1419, minutes of the board dated the 19th of February, so well after the event, and paragraph 12, rather overstating perhaps, in recognition of their fiduciary duty to the fund and its shareholders, it was a bit late by then, the directors confirmed the fund's redemption policy shall continue to be to secure an orderly liquidation, pay out redemption proceeds, and then B, it refers to taking into account where one redemption request of such a size it can only be satisfied in a number of payments or in one deferred payment, the directors may satisfy all other contemporaneous or prior redemption requests in full before paying the redemption proceeds for the large redemption, in order best to protect the net asset value of the fund and the interests of the remaining shareholders. Now, my lords, if that were a true statement, that wouldn't show any intention to prefer. It simply shows a methodology which has a commercial purpose behind it, none of which is preferring, choosing to prefer, in the sense that the directors wish one creditor to be paid ahead of another. The problem, of course, with this and with the letter is that these were written on the instructions of connivance of Magnus Peterson, no doubt to protect the directors and to try and fend off, firstly, as regards the December letter, actions by unpaid redeemers, who say, we'll give you 25%, hold off, don't try and wind us up yet. And then the directors meeting there, the directors trying to protect their own backs by recording something as being in accordance with their fiduciary duties. Now, how much one can take from either of those documents as evidence of Magnus Peterson's intention, one really does wonder. I'll have to go to the cases very quickly indeed. The authorities start off with Sharp and Jackson, and I will whip through these if I may. It's at volume 8, at 2691 to 2692, the relevant part, decision of the House of Lords. And 2691. It's the Earl of Halsbury, 2691. Halfway down, the question of whether there's been a fraudulent preference, not the mere fact there's been a preference, the state of mind of the person who made it. Not only he's preferred, he's fraudulently done so, intention or view doesn't appear to be a matter. Question whether in fact he had the intention to prefer certain creditors. It's been argued the debtor must be taken to have intended the natural consequence of his act. I don't think that's true for this purpose. I think one must find what he really did intend. And then this was a case where he made payments because he thought he was going to be discovered and persons would have a certain hold upon him. And at 425, bundle 2695, passage at the bottom, my lord, seems to me after that decision idle to suggest you must have an actual threat or the actual pressure of a creditor. It's true no one threatened this particular bankrupt with criminal proceedings. The facts are such that each of them described them to be what was in his mind was that when the examination took place, he would, as a matter of fact, probably be prosecuted and sent to penal servitude for an act of misconduct of which he had been guilty. Well, one could hardly get closer to the facts of this case. And there's no reason to suppose that Mr. Peterson didn't anticipate exactly that. Now, the decision in Cohen, my learned friend's case, is at volume 7 at 15, at 2109. Lord Justice Warrington at 538, it's a majority judgment. You see the facts at the bottom on 2138, just starting at the end of the judgment, if you like. The facts here are such to show that the debtor, when he made the payment to Messrs. Snow and Company, must have known that he was about to suspend payment on the following day. It was a case, it really was on the eve of bankruptcy. Sharp and Jackson was distinguished at page 2137 of the bundle. Reference Lord Macnaghten's speech in Sharp and Jackson. Word preference involves free choice. The debtor in that case was not in a position to exercise free choice. He was under an overwhelming sense of peril. Mr. Peterson might have felt himself under an overwhelming sense of peril. But all this case tells you is that if, literally on the eve of bankruptcy, you've given a number of post-dated checks to a number of creditors and you pull one out of the hat and you pay them, it's open to the court. It's open to the court. The court doesn't have to. It's open to the court to draw an inference that there was an intention to prefer that particular creditor, even though you don't know why. You can't actually get into the mind of the bankrupt. The decision was the subject of House of Lords consideration in Peat and Gresham Trust. That's at volume 7, tab 24. At 2431, and the relevant passage is at 2441. This was a case where there was a last-minute withdrawal of opposition to legal proceedings. And at the top of 2441, contended on the appellant's behalf, once the withdrawal and consequence of the withdrawal, absence of any other explanation, the intent to prefer must be inferred. Man presumed to intend the natural consequence of his acts. Do not accept that. The onus is on those who claim to avoid to establish what the debtor really intended. Well, those words I would ask you to consider. What did Mr. Peterson really intend? And that the real intention was to prefer. Owner's only discharge, review of all the circumstances, is satisfied the dominant intention to prefer was present. Maybe a matter of direct, where there's not direct, and there's room for more than one explanation, it's not enough to say there being no direct evidence, the intent to prefer must be inferred. There's nothing in decision in Cohen to justify the doctrine for which the appellant contends. Don't think it could be reconciled with Sharp and Jackson. Present case, bottom paragraph, Mr. Wheeler's actions may have been due to reasons entirely unconnected with the intention to prefer. Improper to speculate what the reasons for his actions were, in my opinion, upon the material available, inference intent to prefer cannot in law properly be drawn. There's a certain ping-pong between the House of Lords and the Court of Appeal, because that decision in turn was considered by the Court of Appeal in Re Kushler, which you'll find at volume 8 at tab 34, and relevant passage at 2585. This the passage just before Peat and Gresham Trust reference on page 2585, just at the bottom. Sorry, before we get there, yes, the Lord Green, about 7 lines down, it's argued the proposition of law to be extracted from what was said in the House of Lords and Peat and Gresham Trust. I must confess, look at the matter, the language of the statute doesn't seem to me to warrant any such interpretation. The statute directing the court to ascertain the state of mind of the payer in relation to a particular transaction. And there, nothing in the language of the section justifies the view the problem is to be dealt with only on any principles different from those commonly employed in drawing inferences of fact. It must, however, be remembered that the inference to be drawn is something which has about it, at the least, a taint of dishonesty, in extreme cases, much more than a mere taint of dishonesty. Courts are not in the habit of drawing inferences which involve dishonesty or something approaching dishonesty unless there are solid grounds for drawing them. Now, we don't say, in this case, that dishonesty has to be shown, but it's interesting that Lord Green, when he's dealing with Peat and Gresham Trust, is drawn to this analogy with something with the taint of dishonesty. When he's, so he says, to understand the language used by Lord Tomlin, important to appreciate the nature of the case and the arguments with which he was dealing, and then he refers to the specific provisions there. And then finally on this, recuts, volume 7 again, and the reference is 2505 at 7.
You say 2505?
Yes, please.
Thank you.
Tab 29. That's another Court of Appeal decision. Is there anything in particular? Yes, just to remind, at page 7, 2505, the passage starting just above halfway down. For if a debtor deliberately selects for payment A in preference to all his creditors, cannot matter whether he's the debtor's oldest friend, close relative, or best client. On the other hand, where he owes money in all directions, has robbed the till, may elect, and so on. Debtor may elect to make pressure on payment under pressure of some threat, obtain some immediate material benefit. In the instances given, the intention, that is the real or dominant intention, will no longer be to prefer, that is to pay, as it were, out of turn. That's an interesting concept in this. Paying out of turn. If you pay your debts in the order in which they arise, you pay the December debts when the December debts arise, the January when the January arrive, you're not paying out of turn. It may be wrong. It may be said, you should have suspended payments altogether. But is
that what he means by out of turn in the context, where if the company is insolvent?
Milo thinks he might mean out of pari passu.
What he gets paid at the same time.
Pari passu
Yeah.
turn. Well, he is, of course, at this point considering the particular instances that he's referring to. But I don't say we haven't run on that point. It's interesting to refer to, but there is an element of paying in turn when you pay people in the order in which they arise. You're not preferring, you don't intend to prefer that creditor. Why do you pay the first creditor first? Because they're the one who can wind you up first if you don't pay them. They're the ones who can, the greatest threat to a company is not from the creditor who became a creditor a day ago, but from the one who became a creditor a month, or 2 months, or 3 months ago. So paying your earlier creditors first isn't evidence of an intention to prefer them. You don't care who they are, but you pay them first because they're the ones who represent the greatest threat. And as we've seen from the cases, Sharp and Jackson and so on, you don't need an actual threat. If you do that because that's how you can keep your company running as long as possible, that's what you'll do. And the question of pressure, the bottom part of this judgment, has in some form or another, has in the reported cases often been the crux of the matter. It's plain that an inference of intention may be displaced many other ways than by showing the debtor acted under pressure. Examples are legion. Close analogy, real question before us is whether upon the evidence, true intention to prefer, whether an inference of some other kind, similar to those in the examples given, is at the least not equally legitimate. So if there is something, an equally legitimate reason, putting off the evil day, and this is what the learned judge at first instance was well aware of. There were other factors. He said you can't apply this to all the other people in that list because there may be a whole host of other factors equally consistent with there being no preference. And then these actual threatened or fear of proceedings at page 2515, halfway down, reference to ex parte Taylor, Sharp and Jackson. So fear of proceedings is again sufficient. Well, let's conclude on the law. Firstly, the liquidator has the onus to show a dominant intention to prefer. Secondly, that intention can be proved by fact or by inference from circumstantial evidence. We would accept that. But the mere fact of payment and knowledge of insolvency is insufficient. And in this context, with House of Lords authority, a man is not taken to have intended the natural consequence of his acts. And with equal authority, no inference of preference can in any case be drawn if the circumstances are equally consistent with alternative intentions. So we can conclude on the facts that in respect of payments 2 and 3, SEB was in no different position from any other December redeemer. There's no evidence of any intention to prefer the December redeemers other than the fact that they were paid earlier. They were paid earlier because their debts were due to be paid earlier. And the likely inference, and after all the whole purpose of sending out that 31st of December letter on the 7th of January, the only purpose of sending out such a letter must have been to hold off redeemers from enforcement action. Could have no other purpose. Your debt has come due for payment. Hold off because this is what we're doing. We'll give you all 25% and we'll hope to pay you the rest by the end of January. It's holding off. That's why they paid. And the further inference, just from the surrounding circumstances, that the payments were made because Magnus Peterson was seeking to hold off the evil day and the start of his inevitable prison sentence for as long as possible. And he did successfully. For 3 months, this company kept alive after these payments. It's liquidated in March. So only by paying creditors in the order in which they came, with the resources available to him, could Magnus Peterson keep the company going. And even if he knew it was going to crash, just as a juggler may know that they've lost balance and the balls are all going to come tumbling down, the juggler will still catch the ball that's closest to the ground first to keep the act going for as long as possible. He doesn't prefer the blue ball to the red ball, but it's the one that's going to hit the ground first. And the December redeemers were hitting the ground. The January redeemers, they were a problem he was going to have to deal with. And then the February redeemers. But he dealt with the problem in the order in which they arose. And there's no evidence that the identity, the actual identities of the December redeemers, had any bearing on anything at all. If one considers the names in that list, as opposed to the names in the February, the January or the February list, we have much the same names, HSBC as nominee for various individuals, UBS as nominee for Ferrum Fund Tactical Trading, appears in the January and the December lists. These names didn't mean anything. And I don't think there's been any case that my learned friend can point to where the actual identity of the creditor that was paid was said to be wholly irrelevant, and it was nonetheless a preference. Difficult to see how it could. Now, it may be, of course, that a creditor with a particular quality, Mr. Peterson had said, there are some creditors who have a particular characteristic which is useful to me. and I want those creditors with that characteristic to be paid first. I understand the Court of Appeal talking about a class being preferred over another class. But to talk about the December redeemers as a class, they weren't a class. They were in the same class as all the other redeemers. They were all shareholders in this company that had redeemed, but they'd redeemed in a different order. But they weren't of a different class. And if the names had been swapped around from the January redeemers, January list to the December list, the January redeemers would have been paid out. Those companies would have been paid out on the same basis first. And these redeemers wouldn't have been paid out because they were January. Now, it's impossible in those circumstances to say that Magnus Petersen intended to prefer the December redeemers to the January redeemers. The identity of the redeemers was wholly irrelevant to the decision to pay. My Lords, just before we break, I will, if I may, just deal with the amendment point, as it's called. It's a very short point, and it catches up the first payment. If the second and third payments were not preferences, then the third payments were not preferences. And you get that from Lewis and Hyde. It's at Authorities, Volume 7. At 2277, tab 20, decision of the Privy Council.
Sorry, page?
The relevant
2273 is the beginning of
2273 is the beginning of the judgment.
Thank you.
And if one picks it up at 2275, just to see the facts,
Yep.
and you'll see it at D to F. January and February 1989, Prudential was in financial difficulties. Application to wind up filed on the 23rd of February. That day, a provisional liquidator was appointed and Prudential stopped trading. From the 2nd to the 21st of February, Prudential continued to trade in the ordinary way. During that period, it accepted $500,000 of new deposits and repaid over $2 million of existing deposits. Therefore, even had Mr. Hyde been required to wait for 7 days for repayment, and also a further period in order to enable a cheque drawn by Prudential to be cleared, he would have been repaid his deposits in full before the application to wind up Prudential had been made. So Mr. Hyde, you'll see just from the immediate paragraph above, he called at the offices on the 2nd of February, sought immediate repayment, told he'd have to wait 7 days, went to see Mr. Morris, arranged for immediate repayment by way of bank cheques. So he was given more than, he was treated better, if you like. He was given special treatment. But in fact, if he hadn't been given special treatment, it'd have been paid out anyway. And the 2277 B is the B to D is the existence of such an actual preference a requirement of Section 309. It seems obvious the section has no application where there's been no actual preference. The effect of the section, if applied, is to require the preferred creditor to repay what he's received, the monies recovered being applicable pari passu between the creditors and the liquidation. The underlying purpose is to ensure compliance with the basic principle of insolvency law, which is pari passu distribution of the insolvent estate. If the creditor from whom repayment is sought has not in fact been preferred, the whole rationale of the section disappears. Far from bringing back into the pool monies which would, apart from the preference, have been available for pari passu distribution in the liquidation, the effect would be to increase the pool by recovering monies which would not, in any event, have been so available. So if you go to 2279 at C, this result conforms with the common sense of the matter. There's no reason to set aside a transaction so as to bring assets into the pool of assets available for distribution amongst creditors in the insolvency, unless the transaction so set aside has in fact diminished the pool, which would otherwise have been available. In the circumstances, it's unnecessary to consider whether Prudential was able to pay its debts. They became due. So, my Lord, see, it's a very short point. It's a very clear one. And the position here is clear. Had the first SEB payment not been made, Weavering would have had an extra $1 million odd in its bank account because it hadn't made the payment. Catella would have benefited from the 25%, 75% policy, and looking at that list, there can be no reasonable doubt that if SEB for Catella was paid out, it would have got the 25% as everyone did on the second, and the extra million would have been there to fund it. It's not it couldn't have been funded. And looking at that list again, there can be no reasonable doubt that it would have been the top three creditors that were not paid on that list. SEB for Catella would have been paid, it would have been lower down the list, and there would have been the money to pay it because it hadn't been paid out earlier. So there can be no doubt at all that if the second and third payments are not preferences that can be recovered, then equally the first payment can't be recovered because it would have made no difference in any event. And to recover it would be to swell the assets of the liquidation, not to restore them. My Lords, would that be a convenient moment? Just to let you know, I will deal with the repayment issues and change of position after the adjournment.
Court will adjourn.